Prominent lawyer and senior advocate of Nigeria, Robert CLARKE, has thrown his weight behind the Attorney General of the Federation and Minister of Justice, Abubakar Malami, over his position on the newly launched security outfit by Southwest Governors, Operation AMOTEKUN. Malami had come under criticism from several quarters for declaring the outfit illegal, but in an exclusive interview with TV360, Robert CLARKE says the governors did not follow due process of law in the creation of AMOTEKUN. The lawyers added that such decision ought to have passed through each state House of Assembly before any official pronouncement was made.
The governors have a right, and let us get it clear, they have the right to create any apparatus that will determine the security of that. But they must follow due process. And that is where they all have gone wrong. In every state, before a governor can exercise executive powers that is not in the Constitution, it must create a law that allows him to do so. So, in the present AMOTEKUN case, each governor should have gone back to his House of Assembly and get each House of Assembly to pass a law allowing that governor to create that outfit known as AMOTEKUN. Because what they are now doing, collectively they are creating AMOTEKUN. There is no legal basis for it. They are not following due process. So the federal government is correct to say it is unlawful. To that extent, I will agree to the federal government. But to the operational aspect of it, I do not agree with the federal government that state governments cannot set up such apparatus if they follow the rule of law.
CLARKE equally gave his position on the Supreme Court's verdict, which nullified the victory of Emeka Ihedioha and declared Hope Uzodinma the duly elected governor of Imo State. The lawyer maintained that the ruling was apt, adding that although the Apex Court gives room for a review of consequential order, the Imo State case does not fall under the perimeter of a case that can be revisited.
I have looked at this judgment. You look at the consequential order made. The consequential order, which is that a candidate should step down for a candidate to step in, is made within jurisdiction. If it is out of jurisdiction, then you can now go back to them. That the consequential orders you have made was made out of jurisdiction. The fact that the Supreme Court has given a judgment does not necessarily mean that you cannot go back to them. They give you that space to come back, but they tell you that in coming back, these are the grounds we will use in looking at you. But looking at this case, as a lawyer of my own standard, I don't think they don't fall within the parameter of the reasons why they can go back to the court.